All right, Ms. Wilson, where did you want to start this one? All right, so we're on the record in docket 24000628. That is people of the state of Michigan versus Jamone Walker. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Silverthorne.
Good morning, Your Honor. Dwayne Silverthorne from the Office of Public Defender on behalf of Jamone Walker, who I see is appearing on screen from the jail.
All right. And sir, you are Jamone Walker, is that correct?
Yes, I am.
Okay, and you can hear me all right, Mr. Walker?
Yes, I can.
All right, this is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe this is going to be left set for preliminary exam next week.
The prelim is set at this time for March 28th at 8:30. Is that a fair statement, Mr. Silverthorne?
Yes, Your Honor, it is.
All right. So we'll leave this prelim on for March 28th at 8:30. Anything else for the record in docket 24000628? Ms. Wilson.
Not from the people.
Mr. Silverthorne.
No, Your Honor.
All right. Mr. Walker, we've left this on for next week. So I'll see you next week on March 28th. All right, sir? All right. Thank you for your appearance today. We're all set.
Your Honor.
Have a good day, Mr. Silverthorne.
And I believe we're ready on Mr. Taylor. I believe it's a sentencing. Gregory Taylor.
Gregory. All right, so we're on the record in dockets 23031110. That's people of the state of Michigan versus Gregory Taylor. Will the parties please introduce themselves to the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Etheridge.
Good morning, Your Honor. Attorney Derek Hitchens, Office of the Public Defender on behalf of Mr. Taylor. Mr. Taylor's in the courtroom at here sitting to my right.
And sir, you are Gregory Taylor, is that correct? Thank you. This is the time set for a sentencing in the matter. Ms. Wilson, is there any restitution on this case?
There is not, Your Honor.
All right, thank you. Mr. Etheridge, have you had the opportunity to go through the pre-sentence report with your client?
Yes, Your Honor.
Any additions, deletions, or corrections?
Yes, Your Honor. Obviously, on the first page under defendant's statement, when it refers to the last page of the basic questionnaire, we did not receive the questionnaire. I have reviewed his statement with him. I don't think we need to go forward with sentencing.
Okay.
On the second page, under employment data, it has him marked as unemployed. He advised me that he is employed at Gregory's Soul Food. He works Tuesday through Saturday, 5 p.m. to closing, and earns around $10.50 per hour.
All right, with those edits concerning employment history and not receiving the survey, are you prepared to go forward with allocution?
Yes, Your Honor.
All right, allocution, Mr. Etheridge.
Thank you, Your Honor. Your Honor, we'd ask the court for the most part to adopt the recommendation. I'd ask the court maybe to consider a lesser term of probation. Your Honor, this individual has some addiction issues. I tried to get him into drug court at the beginning of the case. We adjourned it a couple times for him to be assessed for drug court, but ultimately, as I recall, drug court had filled up and didn't have any openings. So he continued to struggle with his addictions. He is trying to get services through parole. Parole is reviewing his case currently to determine what they're going to do in terms of any type of parole violation or parole issues. My understanding is that they're considering doing another CMH assessment for additional services. He is currently on scram by parole, and they're monitoring his alcohol use through his scram tether. They are monitoring him, and he is getting some treatment through them. He would ask the court to follow the recommendation, as I stated, maybe consider a lesser term of probation, and he is open to any treatment that he can get. He would just ask the court to try to make sure that any services he's getting through parole counts for this probation as well, so he's not duplicating services. Thank you, Your Honor.
Thank you, Mr. Etheridge. Mr. Taylor, is there anything you'd like to bring to the court's attention before the court passes sentence? And Mr. Etheridge has spoken eloquently on your behalf.
I can say I'm going through a lot of treatment right now, CMH, through my parole agent, and he's trying to help me rehabilitate myself through the program instead of jail as of now. And so I would like to kind of go along with him. What I'm trying to do.
All right. Thank you, Mr. Taylor. I've had the opportunity to read the pre-sentence report concerning this matter and the recommendation. I find the recommendation to be a fair recommendation. You've been through this before, or parts of the system before, so you understand that this is your opportunity to really stay clean in this matter. Okay, that's really the concern of the probation agent. Is to use this process and learn from this process. I don't want it to be duplicative, so I'm going to indicate that for the record, that anything that can be used that is being used on parole, but the probation agent you'll see right after this. Okay, I'm going to follow the recommendation. I also believe that a 12-month term is probably more in line for this, but I'm going to follow the recommendation. So this is for a guilty plea on January 12th, 2024. I'm gonna indicate that you're to spend 365 days in jail beginning March 22nd, 2024. Credit is given for 1 day previously served. Suspend 364 days upon successful completion of probation, which means no upfront jail. Okay, it's all being held somewhat as a stick. All right, that this is a good opportunity for you to do what you're supposed to do. Make the probation agent make sure that you take part in treatment, your IOP treatment, community mental health treatment. In that regard, we're supposed to be able to help you here. Okay, so take advantage of our resources. All right. I'm going to set fines: $200 fine, $200 cost, crime victims' rights fee of $75, state minimum court cost fee of $50, for a grand total of $525. And then on 12, it'll be 12 months of probation as opposed to 14 months of probation. So that'll be $360, $30 per month per probation, for a grand total of $525 plus 360. $885. Thank you, Mr. Etheridge. $885. I'll put you on probation for 12 months. No assaultive or threatening behavior as a part of your probation. No use of possession of alcohol, marijuana, or controlled substance without a prescription. I will allow medical marijuana to be used if you have a card. Okay. Submit to random PBTs, enter your analysis as directed. No bars or nightclubs. Under D is marked IOP. So if there's an intensive outpatient that becomes available, the direction is to do what the probation officer says. All right. Attend the 12-step program with written verification. I'm going to indicate that attend the 12-step program. That written verification and times will be as directed by the probation officer. Obtain and maintain employment, which you're already working at Gregory's, so that's part of this. Keep working there. And then any conviction would be reportable to the Secretary of State concerning this driver's license. I'm not sure how they abstract use of methamphetamine. But that is a potential. Okay. anything towards, so I followed the recommendation. Go to probation on the 5th floor right when this is done and talk to a probation agent, or at least find out the name of your probation agent so that so everybody's on the same page, okay? Because for the next 12 months, you're going to have to make sure that the inquiry, I don't know what's going to happen with your parole stuff, but make sure that they know about that, what's going on with parole stuff, and make sure that you understand what conditions are placed on you for probation, okay? All right. Anything else for the record, Mr. Etheridge?
No, Your Honor, thank you.
All right, thank you. You're all set, Mr. Taylor. Good luck to you, okay?
Yeah, I'll take it now.
Thank you.
We were ready on Miss Lily. Viola
Mr. Say it again, Ms. Wilson.
Viola Lily.
Lily, okay.
You're on Skype. Get her from the hallway.
All right. I should change. All right, so we're on the record in docket 2303-819. That is people of the state of Michigan versus Viola Lilly. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Miss Lily, who is present and standing to my right.
And ma'am, you are Viola May Lilly, is that correct?
Yes.
Thank you. This is time set for sentencing in the matter. Ms. Wilson, is there any restitution on this matter?
There is not, Your Honor, and I do have a comment from some of the named witnesses whenever the court's ready.
All right, so we'll hear the pre-sentence report, some allocution, Ms. Schroeder, and then we'll allow and just let me know if I forget.
Yep.
that there's a victim here, or you want to make a comment, just let me know, okay? All right, Ms. Schroeder, you had the opportunity to go through the pre-sentence report with your client.
I did, Your Honor.
Any additions, deletions, or corrections?
She wanted to make, Miss Lily wanted to make known to the court that even though she is currently unemployed now, she was for 20 years prior to the COVID epidemic, that she was employed for 20 years at a salon. That career went down because of COVID shutting everything down. She worked a number of odd jobs from her home for 3 years, including babysitting on other items, but she's been actively seeking employment while awaiting the outcome of this case. Unfortunately, some of them have stated, I think, because of some of her health needs and accommodations, that it has not worked out. And she was hired by Kroger at one point, but even though she disclosed during the interview process that she had this pending matter, they hired her, but then turned around and fired her a few days, like 2 weeks later, after a full background check had come back, which doesn't make a whole lot of sense to me, and it didn't to her. But she wanted the court to be aware that she isn't just someone who has been chronically unemployed. She has actively sought and was very well employed for a very long time. She has no criminal record. I think that's reflected in the report. She does have she indicates to me a lot of friends in the community, as well as family support, who is here today. So she doesn't know where there was a comment made about how she doesn't have any friends and doesn't have like close family. I think there was something to that effect. She doesn't know where that came from, because she indicated to me that was a surprise to her, as she does have a number of close friends and family. She just doesn't go out. She doesn't do the partying thing because she has significant medical issues. So those things she just wanted the court to be aware of. I don't know if they qualify as an addition or correction, but she did want to make the court aware. Is there anything else? Okay. Thank you, Your Honor.
All right, allocution, Ms. Schroeder, and then we'll hear from the victim in the matter or from the opposing, from the people. Allocution.
Thank you, Your Honor. As I'm sure the court recalls, Ms. Lilly pled no contest as to this matter back in, it was January. My brain is having a moment here, Your Honor, but some time ago. Since then, she has been actively engaging in treatment. She has here with her today paperwork from Crystal Ray that if the court wishes to review, she's been attending Alcoholics Anonymous. Would the court like to take a look at that?
No, but make sure that the probation department
Okay.
gets to see that.
Okay, so she has completed, she's working on an assessment. She did an assessment. They have a treatment plan. She sees them every Tuesday in person or on Zoom is what she's been working on. And she also is doing individual counseling and AA/art therapy. Pardon?
That one's group.
That's a group.
Yeah.
Every.
One's individual, one's group.
Okay, so she has been very actively, and she's done this of her own accord prior to even starting probation. I do realize that in the report, she made statements regarding the incident, but I would again direct the court that this was a no contest plea for a reason. This was a heightened situation, and their alcohol was involved, and she is taking steps to handle that. She has no prior criminal record. I would ask the court to allow her the opportunity to serve a term of probation. I would ask that it not be, I believe it's 12 months that is being recommended. I'd ask the court for a lesser term based on the fact that she has already started engaging in substance treatment. She is testing, I believe it's once a week right now. And she has signed releases, she indicates, with probation, so they have information regarding that from Crystal Ray. And the fact that she has a lack of a criminal record at this time, and then I will leave the rest to Ms. Lilly.
All right, thank you.
Oh, one last thing, if I may.
Mr. Hart, go ahead.
She is currently wearing a tether still. Is it a GPS tether? Yes. There have now been no violations that I have been made aware of regarding the tether. And I don't even think the I don't even believe the victim or victims even reside in the same area that they were at the time that this started at. So I would ask that that be removed at this time. I think sometimes when employers see somebody, even if they're not supposed to take it into account, if they see someone on a tether, they kind of start making some assumptions.
All right, and that tether was part of the no contact order. I'm assuming it was zone and victim notification.
That is correct, Your Honor.
Okay. All right, Ms. Wilson, a response or any statements to be made?
Yes, Your Honor. So as part of our agreement, the two assault batteries were dropped as part of this matter, but there was an agreement that the two victims in that matter could make a statement if they wish. Neither of them were able to be here today. However, I've spoken with them. Andrea Wakefield didn't really have much to add at this time. She thought that I went through the recommendations with her and she thought they were appropriate. Ann Wakefield was going to provide me with a statement, but hasn't yet. But based on my conversation with her.
Now you spoke to Andrea Wakefield.
Correct.
The other victim is
Sorry.
Eleni Alvarez.
Andrea's last name is Alvarez. That's.
Oh, is it?
Yeah.
Okay.
Yeah, I have it as.
Yeah, I have it as Wakefield as
I
well.
have Andrea Wakefield and Eleni Alvarez.
Correct. The Albany was the victim on the child abuse matter.
Okay.
That's
And
Evelyn.
Ann Wakefield was one of the victims on the assault and batteries that had been dropped as part of our agreement. They were permitted to make statements today if they had wished. Ann Wakefield indicated to me that I guess her and Miss Lilly have been friends for several years, and she believes that Miss Lilly is not a bad person. She thinks that if alcohol hadn't been involved in this matter, it simply wouldn't have happened. And she really just wants to see Miss Lilly get some treatment because she thinks that that's really where this issue is coming from.
Okay.
So I just wanted to relay that to the court on their behalf.
All right. Thank you. So this is this sentencing. Well, Miss Lilly, is there anything you'd like to say to the court before the court passes sentence?
I'm just very sorry that this happened at all. I obviously never, I don't want anything like that to ever happen again. And I'm doing whatever I need to do to make sure that it doesn't.
All right. All right. All right, Miss Lilly, you're not a kid and I'm not going to treat you as a kid. Okay. I agree with counsel that probation probably is too long here, okay? But I'm gonna only reduce that a little bit because I'm not concerned about your behavior in the next, I'm gonna put it at 10 months, okay? I'm more concerned about your behavior in 5 years from now, okay? This was a pretty destructive situation because of alcohol and mental health problems, and you're working on that. And so you need to continue to work on that, all right? Even past this 10 months, you need to continue to work on that so that your statement to me is valid, that this never happens again.
Yeah.
Because we know this was fueled by mental health and by alcohol, and we can work on that. And we're supposed to help you. Use this as a resource to help you work on that, okay? But for the next 10 months, I'm not too concerned because I know that if you don't do what you're supposed to and you don't get your mental health treatment, then I run out of options, and then jail becomes an option, all right? And that's simply not in my framework, okay? However, I'm more concerned 2 or 3 years from now, you've got to make good decisions. And so you've got to be able to have a somewhat of a healthy relationship with all these things. And that, as you've noticed, that may require some work on your part. All right. So based on the statements that are made by both counsel, this is for no contest plea on January 19, 2024, in regards to the crime of child abuse fourth, which is the misdemeanor. It is ordered the defendant spend 7 days in jail. Credit is given for 7 days previously served. I'm gonna leave the rest to be determined by probation. So I'm not suspending any sentence. So you have no jail up front. Okay. I'm gonna set fines and costs. Fines are set at $300. Costs at $300. Crime victims' rights fee of $75. State minimum court costs of $50. I'm gonna put you on probation for 10 months, which will be $3,300, $30 a month. So I can give you a grand total of 675, let's see, 675, 725, $1,025. Probation for 10 months, $30 a month. I'm going to indicate no contact with the victims. I have Elena Alvarez and Ann Wakefield be within 2,000 feet of where victim lives, works, goes to school without consent. We are doing that without a GPS, okay? I don't see GPS as an issue in this case at this time. So I'll modify that. So that's without a GPS.
Your Honor,
Yes.
if I could just clarify, did you say Ann Wakefield, or, so I believe the victim in the charged matter is Aveline Alvarez.
Evelyn, sorry, no, I can't.
Evelyn Alvarez is who I have.
Okay, I just want to make sure. I thought
And then I have an Andrea Wakefield, and I believe you referred to her as Ann Wakefield.
there was an Ann Wakefield
Okay.
and an Andrea, I guess last name is Alvarez. Ann Wakefield didn't indicate to me that she wished any sort of no contact,
All right.
so I believe that's the court's discretion.
All right, so we'll do as probation request with a no contact as to Alvarez and Wakefield, but that would be without a GPS, without the tether. So no assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance, submit to random PBTs and or urinalysis as directed, no bars or nightclub. As a part of the rehabilitative service, anything as directed by the probation officer in regards to the outpatient substance abuse and mental health treatment as directed and pay fees. Those are the two main aspects of this, all right? Alcohol treatment and mental health treatment. So do whatever the probation officer believes is appropriate for the next 10 months in that, learn from that, and maybe those will give you the tools so that we don't end up here again, all right? Obtain and maintain employment, which you are seeking on right now. Not purchase or possess firearms, ammunition, or weapons of any kind. Do you have any questions concerning the judgment of sentence, Ms. Lilly? All right, you go down to the fifth floor and find out who your probation agent is, because that's the person that you're going to be somewhat someone is going to contact me if there's a violation or not. So you want to make sure that
I know who she is. Do I need to speak with her when I'm,
you
or?
don't have to speak with her. Just make sure you know who she is. All
Oh,
right.
I know who she is.
And yeah, and just make sure you understand what you're supposed to do. All right.
Just for the record, I would still, Miss Lily, go down today and just check in to let them know that you have been sentenced.
I think that's a good idea. I think, and to make sure it wasn't traded off with someone, or you want to know sure who the person you are to report to. All right. I think that's a good idea.
Just go downstairs to the 5th floor, okay? And then.
Do you
turn right.
report, when you report, report by phone or in person or?
That's something that they can go.
Yeah,
over.
that's something they'll go over with you. All right. So what we're trying to avoid, ma'am, is that the less we see each other, the better. But if you get violated by your probation department, by your probation officer, then you show up in front of me, and then I'm forced to make decisions concerning your mental health treatment, alcohol, and then whether jail is the way you're gonna spend your sentence. And right now, I think treatment is more important than jail. But if I start seeing you over and over again, then I start running out of options.
Right.
Okay, so I would check with probation, your probation agent, find out reporting, all those things, so it's very clear, so that there's no violations. All right, ma'am? All right. Anything else for the record in 2303-819, Ms. Wilson?
Nothing from the people.
Ms. Schroeder?
Nothing for the defense, thank you.
All right, you're all set, Ms. Lily. Thank you for your appearance today.
Probation's gonna have copies of that.
Okay.
And you're gonna have to set up an appointment to review there's probation, and that's one of the main things that you go downstairs today. And make sure you set. Because they'll have it all in paper. Yeah, that's one of the first things. You go to the 5th floor, go to the elevator, go to the 5th floor, turn right. Probation is one of the doors.
Okay.
It has a sign probation on it. It's on the left-hand side.
Okay. All right. Thank you.
You're welcome.
Ms. Wilson, I know you've been on the record, so do you need to find out the lineup here, or what are we?
I believe we're ready on Mr. Baker.
We are.
Okay. Right, Mr. Baker.
We are also ready on Redmond, but she is in custody, so.
All right, that's Angelique.
Yes, you're correct. Let me just, you know, run over by me. It's all right. I don't bite, I swear. I know.
All right, so we're on the record in docket 23-03730. That is people of the state of Michigan versus Dwayne Robert Parker. Will the parties please introduce themselves to the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Schroeder.
Assistant Public Defender Aaron Schroeder on behalf of Mr. Baker, who is present and staying to my right.
Okay, it's Baker.
Yes, Your Honor.
We do have that on the pre-sentence. I think that was just an extra R. So, sir, you are Dwayne Robert Baker.
Yes, sir.
Thank you. This is the time set for a sentencing in the matter. Ms. Wilson, is there any restitution on this file?
There is, Your Honor, and I'm preparing a restitution form here now.
All right.
It's my understanding that restitution would be made to Sparrow Hospital in the amount of $10,250.
Yeah. And Your Honor, I do recall that that was part of our plea agreement,
Okay.
right?
And you're working on the red sheet there?
Yeah, and I just completed it if you're ready.
All right.
And I'll talk more to the restitution
All
here
right.
shortly, Your Honor. Okay, yeah.
$10,250. Thank you. All right, and have you had the opportunity to go through the pre-sentence report with your client, Ms. Schroeder?
Yes, Your Honor.
Any additions, deletions, or corrections?
Yes, Your Honor, just on the face of the first page under detainers pending charges section, where it references bench warrants on 2 files out of Eaton County. I actually looked up online, and then Mr. Baker actually brought with him here today paperwork that shows that he actually has been arraigned on those matters as of, and has court coming up on May 1st. He was arraigned on what day? I think it was March 15th. So he was arraigned last Friday. in 50 and 56A on these two cases. He has new court dates as well as with him today, his bond conditions. So,
All right, those are both driving while license suspended.
yes, and that's all been, so he's on the up and up there, so he does not have any pending
All right.
warrants. Everything else, though, from what I understand and what he has indicated to me is correct. Or actually, yes, is correct. I was looking at the wrong paper.
Allocution, Ms. Schroeder.
Thank you, Your Honor. Mr. Baker is an interesting case. It is also a no contest plea that was done for reasons of, at the time he was at Sparrow Hospital, he was there as a mental health crisis. He'd been brought in by the Michigan State Police, I believe, after a suicide attempt. Unfortunately, in the process of all of this, there was a, I guess, break, for lack of a better way to put it, and he ended up causing some damage to property there and shoving around, I think, one of the security officers, if I recall correctly. Is that correct?
Nurse.
I beg your pardon. I beg the pardon on that. Thank you. He doesn't have any memory of this because of the fact, one, he was in a mental health crisis, and two, at the age of 21, he suffered a traumatic brain injury. So his memory is impaired. It is impacted also his ability to read. I do realize he has some record. I realize that he has pending traffic matters. However, I'd still request the court to allow him the opportunity to have a term of probation. He is employed now and can, with a payment plan, make payment toward the restitution. I believe, despite all of his background and such, throughout the entirety of my representation, that he is competent and able to proceed. He understands what's going on. He just had a moment where mental health came into play. But for our reasons, he sought not to go forward with like an insanity defense. And that was a decision he made, as he is allowed to do. And I believe he's competent to make, which is why we are here today. I would ask the court to consider him for probation with something to say with regard to if we can get programming for reading. He really wants to learn how to read. And if there's something that the court can, or probation can assist with that. Thank you.
Thank you. Mr. Baker, is there anything you'd like to say to the court before the court
I'm
passes?
sorry for what I did at Sparrow. I didn't remember it. I was suicide attempt, and I wish some guys here where I can say sorry to him because I don't remember doing it.
All right, Ms. Wilson.
Yes, Your Honor. I would just say that I see here that our probation is recommending PCCs. I don't believe that there was any alcohol involved in this matter, and I think that's a rather costly expense. And I think that Mr. Baker's finances would probably be better. He has a pretty hefty restitution order coming, and I think his finances would be better made towards that than PVTs. As I don't think alcohol was involved in this event.
I would agree with that, Your Honor, and thank you, Ms. Wilson, for bringing that up. I made a note here to do that, but forgot. But I would ask the court to not do testing at this time.
All right, I've had the opportunity to read the pre-sentence and the recommendation. I'm in line with the recommendation. This appears to be an unfortunate situation, and what we want to do is prevent this from happening again.
Yep, I understand, Your Honor.
Some of that's mental health counseling. Some of that has to do with making sure that you get the appropriate treatment that is necessary. I agree with Ms. Wilson and Ms. Schroeder. I did not see alcohol as a determining factor here. So with the understanding of the no contest plea on January 19th, 2024, no contest to the MDOP and the assault and battery, it is ordered that you spend 30 days in jail beginning March 22nd, credit for 0 previously served, and I'm going to suspend any amount of time. So suspend 30 days upon successful completion of probation. That's really kind of the stick aspect of this.
Okay.
I'm going to waive fines and costs at this time. That restitution amount is it's quite a restitution amount, and you've indicated that you're willing to make payments.
Yep.
As a part of probation. You've set up a plan. And I think after 6 months, we'd probably refer the matter to collections based on probation. So I want to make sure that you have a plan for success for that, which is the most important part of that. I am going to place you on 6 months probation as indicated. So that's $75 crime victims' rights fee, state minimum course cost fee of $50. Restitution to Sparrow as indicated per the sheet. So it's $10,250 plus 125 plus 180 at $30 a month, with for 6 months for a grand total of $10,555. That of course can be paid over probation, or that's a large amount. So that'll mostly likely be extended after you're placed on probation for 6 months. No assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription. I do allow a medical marijuana. So if you're able to come up with a card and show it to the probation agent, I would allow that. I'm striking the submit to random PBTs in your analysis, as I just don't see that as part of this. No bars or nightclubs, probably a good idea.
Yep,
You know, to stay out of that
I don't
arena.
go there anyway.
I'm indicating complete the following rehabilitative services. The main one would be continue any mental health counseling and sign a release for the probation agent so that they can be, so they'll be aware of what you're doing.
Okay, yep.
Obtain and maintain employment, not purchase or possess a firearm, ammunition, or weapons of any kind. I'm checking box X, other comments, anything that's available that would be helpful for the treatment of reading. I think that can be a wonderfully effective way of relieving any type of stress or anything, or really just creating an environment that a library card can do a lot. Let's put it that way. Okay.
Yep.
A library card can do a lot.
All right, cool.
Anything towards the judgment of sentence, Ms. Schroeder,
Nothing, Your Honor. Thank you.
Ms. Wilson.
Thank you, Your Honor. I do see that Mr. Baker is also scheduled for a P53 violation here today.
What?
It's my understanding that that violation is because of his DWLS that he has going in Eaton County. So I think that should just be
All
dismissed
right.
here.
All right. So at the request of, based on some of the representations, I did see that, and
I could,
so that, but based on the representations of the arraignment on those two traffic matters, the DWLS will be dismissed as part of the violation of PA 53. Anything else, Ms. Wilson?
Nothing from the people, Your Honor. Thank you.
Anything, Ms. Schroeder?
just to clarify to Mr. Baker, that just means that the violations of your bond have been dismissed. It does not mean the cases themselves. You still need to
Okay,
appear for
yep,
court in
yep.
Eaton County, okay?
Yep, I
All
know.
right, very good. Thank you.
Right. The violation of bond, exactly what Ms. Schroeder just said. Okay.
Yep, not a
Exactly what
problem,
Ms.
Your
Schroeder just said.
Honor. Yep.
Do you have any questions concerning the judgment of sentence, Mr. Baker?
No, I don't, Your Honor.
Right. You should go down and make sure who you're reporting to.
Yeah, I got him.
All
I
right.
got his card right here.
Perfect.
And I'm
Perfect.
gonna go down and talk to him anyways.
All right.
'cause We
So-
got along.
All right. That sounds good. Anything else, Ms. Schroeder?
Nothing, Your Honor. Thank
All
you.
right. Good luck to you, Mr.
Yep, thank you, Your Honor. Have a
Thank
good
you, Your Honor.
day.
Baker. No, you're.
You know what the issue is. Okay, very good. You too, be safe.
You should see my notes. On base. I'm surprised. I don't know what's worse, my handwriting or my note taking.
So I know we've had some people in jail for a little bit. Martinez is not sure.
And then
She-
who is in the dark?
Oh,
All right, so Mr. Who is Mr. Oswald? And you'll. That's a Zoom user, Mr. Oswald?
Yes.
All right. Mr. Oswald, you can unmute.
Okay, I got it.
All right. All right, so we're on the record. Docket 08088854. That is the people of the state of Michigan versus Greg Oswald. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Goodrich.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Oswald, who is appearing over Zoom today, Your Honor.
And sir, you are Greg Oswald, is that correct?
Yes, Your Honor.
And you can hear me all right, Mr. Oswald?
Yes, sir.
Okay, thank you. This is the time set for probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're going to leave this set for next week.
So this is set, this is left on for prelim on March 28th at 9 a.m. So Mr. Oswald, please keep in contact with your attorney, Mr. Goodrich. Your preliminary examination is left on for March 28th at 9 a.m. All right, sir?
Yes, sir.
All right. Anything else for the record? 08088854, Ms. Wilson.
Not from the people, Your Honor.
Mr. Goodrich.
No, Your Honor. Thank you.
All right. I'll see you next week on March 28th, 2024. Mr. Oswald, you're all set.
All right. Thank you, sir. Thank you, Ms. Goodrich.
Thank you.
Who's next?
Martinez or Trevino are both in the courtroom.
Let's do Martinez.
Yes, but he's in jail.
He's in jail, right?
Let's see.
Right, so we're on the record in docket 23033822. That is people of the state of Michigan versus Ruben Martinez. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Goodrich.
Attorney Luke Goodrich from the Public Defender's Office, filling in for John Abbott today and representing Ruben Martinez, who's standing to my right.
And sir, you are Ruben Rosas Martinez?
Yes, Your Honor.
Okay. This is the time set for a sentencing in the matter. Mr. Goodrich, have you had the opportunity to go through the pre-sentence report with, or the probation pre-sentence report with your client?
Yes, I have, Your Honor, and we do not have any changes or corrections.
Okay. Elocution, Mr. Goodrich.
Thank you, Your Honor. Your Honor, Mr. Martinez recognizes that he clearly acted inappropriately on this occasion, and he knows he needs to get some counseling to address these issues. He's had, this is the third time now he's had some type of assaultive offense. He's certainly willing to do better as intervention. I would ask the court, rather than immediately ordering 52 weeks, to order him to do better as intervention, let him go to Pat's, whatever place he's sent to, have them do an assessment and determine what is necessary for Mr. Martinez in this situation, whether that be 26 weeks, whether that be 52 weeks, and essentially just kind of let them decide based on their evaluations. He did lose his job while he was in jail as a part of this. So these type of issues have continued to be a problem in his life. He's been working on finding a new job. Having a tether on his leg has made that difficult, though we should be able to get that taken off today. He lives as a single father of one child. So he's been, like I said, under pressure to essentially get going again, finding a job to help take care of his son. I would ask the court to consider initially granting a term of 12 months of probation. With this type of offense, you can't cut it in half if he gets everything completed early. So with that, I would ask that the court order 12 months. And if it needs more time, the court's always welcome to add time later, but you can't subtract from 12 months when you have an assaultive crime. So I just ask the court to take that into consideration. Otherwise, I feel most of the recommendations are appropriate here, Your Honor.
Thank you. Ms. Wilson, is there any restitution on the matter?
There's not, Your Honor. Thank you.
All right. Mr. Martinez, is there anything you'd like to say to the court before the court passes sentence?
I realize I've made a mistake. I realize the way I handle things isn't correct. And I realize I need help to correct the way I handle things.
Ms. Wilson, did the people want to be heard on the sentencing of Mr. Martinez?
Your Honor, I'm a little concerned about the kind of minimization that appears to have occurred in the sentencing So I know Mr. Goodrich is asking for 12 months. I think 18 months at this time is appropriate, but I would leave it to your honest discretion.
Thank you. Right, Mr. Martinez, this is the sense of the court is for the guilty plea on January 12th, 2024, the domestic violence of second, which is a 1 year, 1 year misdemeanor in this court. I think Mr. Goodrich has eloquently argued on your behalf. We have a problem, right? And the problem is that for whatever reason, you hit the person that you're supposed to care about. And that's just unacceptable. And and you've gone through this one time before, right? And now, and so this is domestic violence second. So we're working on a 1 year offense on that. If the court's judgment of sentence seems harsh at this time, it is because I don't want to go. A third time is going to make it a felony. Okay, and for whatever reason, you're not getting the help we can assist you with in order so that you don't do this again. Okay, but a lot of this comes down to you and whether you want to face another charge on this. Okay, you got to stop hitting the people you love. I know it's easy for me to say that, but for whatever's happening. So I'm going to fashion a sentence that's meant to help you. Okay. It's not going to seem like it, but it is meant to help you. I'm not going to order any jail up front. Okay. And I could. Okay. And to tell you the truth, Ms. Martinez, I kind of struggled with it. This is a 1 year offense. Right. But I am of the mind that we're going to assist you today in getting you the help you need, in getting you treatment of some time, so that this doesn't happen 4 years from now. Because it happens 4 years from now, it's a 2 year, and then we're just compounding a problem. And I don't want to compound a problem. Okay, the district court's supposed to assist you in having the resources to do what you need to do. All right. So the judgment of the court is to spend 17 days in jail beginning March 22nd. Credit is given for 17 days previously served. I'm going to suspend 180 days as a condition of probation. So 6 months are being used as a stick. Okay. And that's to complete probation. I am leaving probation at 18 months at this time. All right. I'm going to issue fines and costs on the domestic violence at $300 fine, $300 cost, crime victims' rights fee of $75, state minimum cost fee of $50, probation for 18 months. So for a grand total of $1,265. That can be paid over the course of probation for 18 months. You're placed on probation for 18 months at $30 per month. No contact with the victim, Kamari Rolak, or be within 2,000 feet of where she lives, works, goes to schools without the consent of the court. No assaultive or threatening behavior. No use of possession of alcohol, marijuana, or controlled substance without a prescription. I will allow medical marijuana if you're able to provide a appropriate card to your probation officer. Submit to random PBTs and or urine analysis is directed and pay fees. No bars or nightclubs. The domestic abuse, I'm going to go ahead. This is a second. I'm going to go ahead and indicate that I'm going with the recommendation. The recommendation is 52 hours, 52 weeks of DV counseling. That can be less. I'm going to leave it in the discretion of the probation officer. But that is a rehabilitative service of domestic abuse. Is whatever counseling they tell you to do, you do. Okay. If it's 52 weeks, you do 52 weeks. If it's less than 52 weeks, you do less than 52 weeks. They're the experts in this matter, and they're the people that this probation officer is the one you want to keep happy. If that seems like a lot of authority given to the probation officer, it is. Okay. I mean, you see it right. But this is in lieu of sending you to jail. Okay. And so I think this is a good treatment plan in order so that it doesn't happen again. Okay. That's what we're working on. We don't want this to happen again. Obtain and maintain employment as indicated. Your council indicated you're already working on that. Not purchase or possess firearms or ammunition or weapons of any kind. Do you have any questions concerning the judgment of sentence, Mr. Martinez?
No, Your Honor.
All right. Well, the tether issue was brought up because of the no contact
So
order.
that
I'm
should be
assuming.
ending, the tether would be ending today. as
Right,
far
it's
as
not a part of the
bonding.
probation, right? Right. It's a part of the pretrial services bond condition. I'm indicating no contact with the victim, Ms. Rolak. I'm not indicating that you're notified, but the one thing you can do that is going to change all the behavior in this is I get a report from the probation officer that you had some contact with Ms. Rolak. And then that's going to put you right in here. And I'll tell you right away, it's going to be really difficult not to place you in jail at that time. Okay. It's just, I mean, it's going to be very difficult. That's a non-technical violation. So that'll be a contact of the PA 53. It's also a contempt order, no contact order. So, I mean, it goes to your help, to help you not to have any contact with you. Anything towards the judgment of sentence, Ms. Wilson,
Not from the people around. Thank
Mr.
you.
Goodrich.
No, Your Honor.
All right. I will sign the new judgment of sentence. You should go down to probation. Just make sure you know who the probation officer is, and you should be all set, sir. Okay? All right. Thank you.
Yeah, they'll give you that sheet. Thank you.
And then I think we're ready on Ms. Trevino.
All right, so we're on the record in docket 24-00030. That's people of the state of Michigan versus Elisa Trevino. Will the parties please introduce themselves for the record? Ms. Wilson,
Kevin Wilson with people.
Mr. Goodrich.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Trevino, who's standing to my right today.
And ma'am, you are Elisa Trevino?
Yes.
Okay, thank you. This is the time set for a sentencing in the matter. Ms. Wilson, is there any restitution on this case?
There is not, Your Honor. Thank
All
you.
right. Any, Mr. Goodrich, have you had the opportunity to go through the pre-sentence report with your client?
Yes, we have, Your Honor.
Any additions, deletions, or corrections?
No, Your Honor.
Allocution, Mr. Goodrich.
Thank you, Your Honor. Your Honor, since Ms. Trevino got out of jail this last time, a couple months ago, she moved in with her mother. Her kids live with her now. She's got a stable place. She has quit associating with all of her friends and cohorts who were part of the meth circle that she had been in. She no longer sees those people. She's been working hard to stay away from that. She has been doing drops through, I think it's bond out of 55th, and she hasn't had any positive tests that I'm aware of. She's done a couple of sessions of therapy at CMH. So she has been taking this very seriously. I think she knows that, you know, her kids and future are on the line here. And she has been taking the steps necessary to stay away from meth and not go down that road and become a productive citizen and a productive mother and somebody that everyone would want to have in society. So I would ask the court to follow the recommendations in this case. I think they're a very fair recommendation across the board here. So we would just ask the court to follow that. Yeah.
All right. Thank you. Ms. Wilson, any comment on this case?
No, Your Honor. I think the recommendation's appropriate.
All right. Mr. Trevino, is there anything you'd like to say to the court before the court passes sentence?
I know what I need to do is maintain a long-term sobriety for my children and myself, because I
Okay.
don't want to go back to jail.
All right. All right. Well, this is for a guilty plea, guilty on January 12th, 2024. This is for count 1 of use of methamphetamines. I've heard the allocution of counsel. I agree with everything that I see in front of me. You've you've been in the back, so you've heard how I discussed this. This is not easy. Okay, you know that. You've been sober now for a period of time. You think differently, you act differently. You essentially are a different person. And I'm glad to see this is the person you want to be. Okay. I think that's good news. But it's a long road and you're a young person. Okay.
Yeah.
So you've got to stay vigilant. Okay. It's not like it goes away. All right. It's there every day. But I'll tell you what, it's worth it. It really is worth it. It's worth it to you. It's worth it to your family. It's worth it to the people who love you. I've seen a lot of this and I know how difficult it is. Okay. And not only difficult daily, it's going to be difficult 10 years from now, 20 years from now, 30 years from now, but that's okay. Okay. That's okay. That's just part of the understanding of the process. At district court, we're supposed to help you. I think this is structured to help you. Okay. To help you, give you the tools so that you can manage everything that comes forward. I'm not worried about you. You heard me. In the next 6 months, I'm putting on 6 months probation. What I'm really worried about is Mr. Trevino in the next 6 years. All right, because and it sounds like you're worried too. All right, and you should be. All right, and you should be. But this can be done. People do it every day. All right. So I'm going to indicate that is the order of the court to spend the next 30 days in jail, credits given for 8 days previously served. 22 days were suspended upon successful completion of probation. That's kind of the stick. Okay, you've got that over your head per the 6 month. I don't intend to use it. I think you've proven to me that this process is going to work for you. I'm going to issue the fines and costs of $250 fines, $250 costs. Crime victims' rights fee of $75. The state minimum court cost fee of $50 for a grand total of 625 and 180, 805, $805. That can be paid upon the condition of probation. I'm going to put you on probation for 6 months at $30 a month. No use of assaultive threatening behavior. No use of possession of alcohol, marijuana, or controlled substance without a prescription. I am allowing medical marijuana as a prescriptive device. So if you provide a card, we'll treat that as a prescription, all right? But any prescription, you want to be real careful with, right? Submit to random PBTs or urinalysis as directed. No bars or nightclubs. Provide substance use assessment and follow recommendations associated with that. With the assessment, that may be at the discretion of the probation agent. They're there to help you, okay? They're there to make sure that you get the help you need. So we don't worry about this 6 years from now, okay? Obtain and maintain employment, not purchase or possess a firearm, ammunition, or weapons of any kind. Any questions concerning the judgment of sentence? Mr. Trevino, do you have any questions? Mr. Goodrich?
No, Your Honor.
All right. I would go down and talk to the probation agents on the 5th floor. Just make sure you got the name and who you contact. And it sounds like this is this should be a positive experience. I know it's come out of a lot of negative experience, but we're here. Use this as a resource to help you have the tools so that you can go on and you can be the person you want to be. All right. All right. That's all for the record in docket 240030. Good luck to you, Mr.
Wait, did you need paper?
I printed it. Okay, thanks. Did anything come? Oh, sorry.
Still recovering from the loss.
I don't.
I only say that because I really don't have a dog in that basketball fight right now. I guess Colorado's still in it.
You have the court file.
I do.
Do you know who's sitting in the dark?
I can ask.
Okay.
I'll ask who's in. All right, so in the lighted Ingham County jail post, please identify yourself, sir. What's your name, sir? Is that Joseph?
Hey, Joseph.
Is that?
Joseph Leamy. He was scheduled
Yes.
for 8:30, I believe. That's a.
Oh, Joseph. So, sir, you're Joseph Leamy?
Yes, sir.
All right, thank you. And then in the Ingham County Post, without any light on, would you identify yourself?
Yes, I will, sir, because I was been waiting
So
for this day.
Yep, you're Joseph Leamy. Who's in the other room?
I have no
Yeah.
idea.
So in the so I have you, Mr. Leamy. In the other Ingham County Post in the dark, would you identify yourself?
I don't see any other incomes. The only thing I see is just.
Mr. Leamy, I got you. You're good. I can see another person. So I've got you identified. I see another person. There you are. What's your name? What's your name, ma'am or sir?
Is there name?
Oh, okay, that's another Mr. Freeman.
Okay, that is Mr. Daniels.
Yes, I believe so, yeah.
All right.
I think we're ready then on Mr. Vickers.
Mr. Vickers is not gonna be here. We're just gonna leave it on.
Right,
All right.
yeah.
All right, let's go ahead and put that on the record.
Yeah.
That's- All right, so we're on the record in docket 24-00717. That's people of the state of Michigan versus Jason Vickers. The parties, please introduce themselves to the record. Ms. Wilson.
Abigail Wilson to the people.
Mr. Sartz.
Good morning, Your Honor. Jacob Sartz, fourth assistant public defender here on behalf of Mr. Vickers.
And we're waiving the appearance of Mr. Vickers today, is that correct?
That is correct.
All right, this is the time set for a probable cause conference. It's my understanding this is to be left on for preliminary examination on March 28th at 9:30. Is that correct, Ms. Wilson?
That is correct, Your Honor. Thank you.
Mr. Sartz, is that your understanding?
That's correct, Your Honor. Apparently, Mr. Vickers had some holds out of other jurisdictions, Eaton County, Clinton County. He was transferred over from Ingham County Jail, to Eaton County. Unfortunately, I didn't find out about it until yesterday. So
Right.
at this point, he will be lodged either Eaton County or possibly Clinton County.
All right.
Let's return to Ingham County.
All right. So, well, you should be rid out of Ingham County. You should come over on the transport, hopefully. But we'll leave it on for March 28th at 9:30. Anything else for the record? 24-00717. Ms. Wilson.
Not from the people.
Mr. Sartz.
No, Your Honor.
All right. Thank you. Thank you for your appearance today.
And then I think we're ready on Mr. Claiborne as well.
I'll check the home one last time. I haven't seen him.
Do I have to say something or talk out?
All right, so we're on the record in docket 24-00716. That is people of the state of Michigan versus O'Donis Claiborne. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson to the people.
Oh,
is he?
here he is, right?
Okay.
What, did you want to talk to him?
I don't have I have to borrow one of the tablets, but we can just leave it on for the preliminary
Okay,
examination
all
next
right,
week.
listen. All right. So we are on the record in docket 24-00716. Ms. Wilson has indicated her presence for the record. Mr. Sartz.
Thank you, Your Honor. It appears that Mr. Claiborne has appeared by Zoom. We'll just leave this matter on for the preliminary examination as currently scheduled. Your Honor, apparently there's some issues with getting our appearance over to the prosecutor's office, but I took care of that issue this morning. Our notes reflect March 13th, but I was informed that the prosecutor's office is claiming they didn't have a copy of it. So I sent a copy over this morning, and so I should have the discovery time for the preliminary examination. I would just request at this stage that we leave the preliminary examination as currently scheduled.
All right, thank you. And sir, you are Adonis Claiborne, is that correct?
Yes, sir.
All right, this time set for probable cause conference. As you heard, discovery is being provided to Jacob Sartz in relation to this preliminary examination. We have left the preliminary examination on for next week. That's March 28th, 2024 at 9 a.m. Right, sir?
Yes, sir.
All right. So that'll be a live in-person preliminary examination. You should be live on the 6th floor of City Hall of Lansing. If you have any questions, please keep in contact with your attorney, Mr. Sartz. That'll be live at 9 a.m. All right, sir?
All right, thank you.
Okay. Anything else for the record in 2400716, Ms. Wilson? Mr. Sartz?
No, you're on. Thank you.
All right. All right, Mr. Claiborne, we'll see you next week at 9 a.m.
All right, thank you.
Thank you, Ron.
Thank you. Sure.
I still have a word to say after that. If you guys don't mind. I'm waiting, Your Honor. Sorry, if you have a question, just let me answer it, and I want to answer the question. Okay. Just give me the answer. I mean, give me the question and I will answer it.
All right, Mr. Daniels and Mr. Leany, we are waiting. Your attorney's in another courtroom. And so once your attorney gets here, we'll call your case.
Okay, thank you. This, they went back in the corner.
So we're on the record in docket 23-03795. That is People of the State of Michigan versus Angelique Marie Redmond. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Ms. Redmond, who is present and standing to my right.
And ma'am, you are Angelique Redmond, is that correct?
Yes.
Thank you. This is the time set for sentencing today. Ms. Wilson, is there any restitution on this case?
Thank you, Your Honor. The victim has requested restitution. However, our office has attempted to get some sort of receipt or something from him. He said he was gonna get it to us and then never did. So I guess at this point I would leave whether or not you want to leave that open to your discretion.
Okay. But at this point in time, there's no restitution that is requested because you've not been contacted by the victim.
That's correct.
Do you know how long ago that, I see that the plea was on January 11th.
That's correct. And then we attempted contact in February and got no response. One of my advocates did speak with him recently and he had requested information about their crime victims compensation board. So I suspect that he's gonna try to get some kind of restitution through there instead of through this process.
All right, with that understanding, Ms. Schroeder, have you had the opportunity to go through the pre-sentence report with your client?
Yes, I have you on. I have your honor.
Any additions, deletions, or corrections?
Just that on the front page here, comment as to time, the date in custody. By my calculation, since she's been in since December 25th, by my calculator, she should have credit for 89 days as of today, which would give her an additional 9 days from the 80 that was originally stated. And then I do have comments as to the restitution as well in a moment.
Okay. So we'll check into the 80, there's 80 days previously served. You said there's indicated another 9 days pursuant to doing the math on that.
Yes.
And then any statements as to restitution?
Thank you, Your Honor. With regard to the restitution, part of the plea agreement was to pay restitution on this matter. That is not in dispute from the defense. However, my objection would be to setting out for restitution at this time based on court MCR 6.425D for N1 for NF that states that at sentencing, the court shall impose the restitution. The amount is supposed to be known at that time and be placed on the record. And we're at sentencing. There have been attempts made to get the restitution amount, and it has not come to pass. I would ask the court at this time to not order restitution. Thank you.
Thank you. All right, anything towards allocution, Ms. Schroeder?
Thank you, Your Honor. Ms. Redmond, she is a woman who's got a lot of trauma, a lot of trauma. She lost a son last year in a very tragic, I believe, car accident. Is that correct? Car accident. She's had a lot in her past that she's still trying to deal with. She has worked extensively with our offices. Social worker, Ms. Maria Kleckner, who is here today and in the front row. Ms. Kleckner has been working with Ms. Redmond for over 2 years on various matters, trying to help her get the trauma therapy that she needs, the substance abuse treatment that she needs. And it has been an uphill battle. But Ms. Kleckner has indicated to me that she has heard change talk from Ms. Redmond, that Ms. Redmond wants to go and do treatment, wants to do what's necessary to get herself well again. I would ask the court to give that opportunity, either by way of a time served sentence at this time, or if the court is inclined to order additional jail time, to allow for that jail time to be released to treatment when available, to serve out the remainder of any jail term in treatment, if the court wants to give significant additional jail time. I do realize that probation has been a hard haul for her, but she seems in a good mindset, but she is currently under probation, I believe it's Judge Aquilina. And then the matters in Clinton County are some fines that have not been paid. So I would ask the court, if the court is inclined to do jail time, to either no additional jail time, or if there is additional jail time, allow for release to treatment. Thank you.
Thank you. Ms. Wilson.
Thank you, Your Honor. In reading the PSI, it does appear that there is some significant mental health issues going on here. And it also appears possibly some substance abuse issues. So the people would have no objection if the court's going to impose additional time, that time be served in some sort of out or inpatient treatment facility or something along those lines. Thank you.
Thank you. Ms. Redmond, is there anything you'd like to say to the court before the court's past sentence? Ms. Schroeder has spoken eloquently on your behalf.
I just apologize for giving you guys a really hard time. I'm working out kinks, but I stayed. The reason why I deferred my PR bonds pretty much to be clean is the only way I'm going to be able to function as a regular person in society. And so I love me enough to stay clean. So
I couldn't agree with you more. Okay. And it seems to me from the reading of the file that there's been some self-medication involved concerning this matter. And you understand that puts you on a path of real problems, ultimate problems. I agree with the judgment of sentence, but I also agree with both lawyers that treatment should be a part of this sentence. So based on the attempted RNO guilty plea on January 11, 2024, it is the order of the court, you spent 120 days in jail beginning March 22nd. There's credit given for 89 days to be served. The 80 credits given for 89 days. I will indicate under other, find it, that you can get day for day credits for any treatment, for any inpatient use in a treatment facility. Okay, so if they're able to find someplace in regards to mental health or substance abuse that would be helpful to you, you can spend time in the facility for the remainder of the sentence. Right, whenever that's appropriate. That's day for day credit. Now it has to be some facility that has a lockdown facility, because I can't have you be an outpatient where you're able to leave whenever you want, because this is a part of your jail sentence. Okay. I think if anything, this is supposed to be helpful. District court's supposed to be helpful. And so, and you're on the right path right now. You really are. And it's not, as you know, it's not an easy road.
I don't have a problem with treatment. I would love it. It'll help me further.
Well, then take advantage of it. Okay.
Yes.
Take advantage of us, because we're a resource that you're supposed to use. So day for day credit on remainder of sentence. Ms. Schroeder.
Yeah, I just wanted to clarify. So if I'm understanding correctly, if we are able, once we're able, because I assume we will, locate a bed someplace like, say, House of Commons or Bear River or something of that nature, she would be allowed to be released to that facility once we confirm she.
Correct, but she'd have to be transported, things of that nature.
Your Honor, can I say
Sure.
something?
You have to give your name.
Oh, sorry. Do you want me to come up?
Sure.
Okay. Sorry, I just wanted to clarify.
State your first name and spell. Yeah, spell both your first and last for the record.
Maria Kleckner, MariaKloeckner.
Okay.
I just wanted to say that there are actually no true lockdown facilities for treatment for substance use in the state of Michigan. We could do something like tether to treatment or something like that, but even TRICAP is not a true lockdown facility.
So any facility that would allow her to take place as tether would suffice for my purposes.
Okay.
For treatment purposes.
Okay.
I just, if she leaves treatment, then we got to know, because then there's going to be a bond violation and we're going to get down this road again. But any treatment facility that's available that goes through a tether order, that's fine.
Understood.
Okay.
Okay. Thank you. I just wanted to clarify.
So day for day credit for the remainder of the sentence, and then after the sentence is over, that's completely up to her. Okay. All right. But day for day sentence on the remainder of the sentence, which is 31 days is left on the sentence with the credit for 81 days. It would be 31 days left on the sentence. And then any facility that takes the tether. We'll take a tether to facility. For treatment purpose.
There are 3 places in Michigan which are
So
now
that,
one is in Lansing.
And so you understand the nature of it. It's if you don't follow through with treatment, they're going to contact us. There's going to be a violation. That's what we're trying to avoid. Okay, trying to avoid all that. But as soon as we get the order, any treatment facility for day credit will be acceptable. Okay, and then tether should be a part of that. Anything concerning the factual base, anything concerning the judgment of sentence, I'm not ordering restitution at this time, since we've had ample time to get restitution or get some remark from the victim concerning restitution. And it appears there may be a different avenue that the victim may be using in that regards. But I'm going to abide by the Michigan court rule. We haven't had no contact with the victim. This goes back to January of this plea, so I'm not ordering any restitution at this time. I'm going to waive fines and costs. I'm going to waive fines and costs, and I'm going to waive the state and crime victims fee. So the total and no restitutions order. So you're done with the sentence. What's left of the sentence is any incarceration or any treatment center. All right. You should be done in regards to this judgment sentence. Any question, Ms. Wilson?
None from the people.
Any questions, Ms. Schroeder?
The judgment of sentence will, I know I'm
Right.
a broker, good. It will convert to allow her to be released automatically, or am I going to need to submit some additional documentation, or someone from my office is going?
Yeah, I think the clerks will send it.
Okay, very
Yeah.
good. Very good.
But if I'm wrong, I'll let you know.
Very
okay?
good, Your
All
Honor.
right.
I just wanted to make sure that we don't, I want to make sure if we
Right.
do have a bed that becomes available, say in a week or something, she can be good to go.
Absolutely, absolutely. Ms. Redmond, do you have any questions on the judgment of sentence?
Don't give up on me yet.
I'm not.
You'll see me on a billboard, but it'll be positive.
Okay, I'm not giving up on you. Good luck to you, okay, ma'am? All right, thank you.
Take care of yourself. That's no worries. I just wanted to ask you before I did. You take care.
This one's gonna.
Take care of yourself and don't forget to go get your stuff from Pam, okay? All right.
And then I believe we're ready on Mr. Freeman's clients.
I see Mr. Freeman. You come forward, Mr. Freeman.
Thank you, Your Honor.
I think his other client might still be stuck in a breakout room.
Did you want me at the bench?
No, you can be right. So, yeah. So let's do Mr. Leany first, right?
Right.
And then we'll do. All right, so we're on the record in docket 24000694. That's people of the state of Michigan versus Joseph Leany. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Freeman.
Stephen A. Freeman, Assistant Public Defender on behalf of Mr. Leany, and he appears by Zoom.
And sir, you are Joseph Leany, is that correct?
Yes.
Okay, thank you. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. And speaking with Mr. Freeman, I believe this might be a competency referral, but I will defer to him.
Mr. Freeman.
Counsel is absolutely correct, Your Honor. Every piece of information I have regarding Mr. Leany suggests that. On the other hand, before I actually prepare a petition and present it to the court, I would enjoy an opportunity to go visit with him for a little period of time out of the jail. I want to know more about him and his background and so forth, so that if I present such a petition to the court will take it in earnest. Thank you.
All right, so let's leave on for the March 28th date, and that will provide us some time. So we're going to leave on for prelim on March 28th at 8:30. And then Mr. Leany, your attorney, Mr. Freeman, will be out to see you concerning this is only a probable cause conference. So we're leaving it on for prelim. That'll give the opportunity for Mr. Freeman to come talk to you. Okay, sir? Is that a yes?
Yes, yep.
All right, thank you. All right, anything else for the record in 24000694? Ms. Wilson,
Not from the people, Your Honor.
Mr.
Thank you.
Freeman.
No, Your Honor, thank you.
All right, you're all set, Mr. Leany. Thank you. We'll see you next week on the 28th at 8:30. You're all set. You can contact the jailer that you're all done, okay?
I think he's in a breakout room,
Want me to move him here?
if you can.
Yeah, I think I can.
The lights get turned on.
I'm not sure.
I tried to explain.
Yes.
There it goes.
Yeah.
All right. I believe this is Mr. Daniels.
Yes.
All right, so we're on the record in docket 23-02806. That's people of the state of Michigan versus Zarek Daniels. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Freeman.
Stephen A. Freeman, Assistant Public Defender, for and on behalf of Mr. Daniels, who appears by Zoom.
And sir, you are Zarek Daniels, is that correct? You'll have to say yes, sir.
Yes, sir.
Okay. Or you can say yes. I just want to make sure you're who you're supposed to be. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that this is going to be left set for preliminary exam, but before then, there may be a petition for competency depending on further communication with Mr. Freeman and the defendant.
All right, so we are leaving this on. Is that a fair statement, Mr. Freeman?
Yes, Your Honor, it is.
We are leaving this on for preliminary examination for March 28th, 2024 at 8:30. In the meantime, Mr. Daniels, your attorney, Mr. Freeman, will be out to see you concerning the preliminary examination. It's set for March 28th at 8:30. Anything else for the record in docket 23-02806, Ms. Wilson?
Not from the people.
Mr. Freeman.
No, Your Honor.
All right, thank you. You're all set, Mr. Daniels. Thank you for your appearance. Your attorney will be out to see you.
Oh, I'm sure. Yeah, no, totally fine. Yeah. We just weren't sure where
I
you
was
were
in the
at.
building at
Yeah,
8:15.
I saw you walk in.
All right.
Think we need to
We'll see you, Mr.
totally
Freeman.
leave again.
Thank you very much, Your Honor. Enjoy your weekend.
You too. I have Mr. Mangalo.
Yes, he is incarcerated. The two individuals may be needed to toll vacate.
Okay. All right, so Mr. Daniels, if you let the jailer know that that room is free, you should be all set, okay, sir?
Okay.
So, Mr. Goodrich, are you here on Gunner York?
Yes.
Oh, there you are.
He's on.
Good to go? You're good to go, yes.
Thank you.
Thank you.
Enjoy your weekend.
You too.
Mr. Margolo was in post 3 yesterday.
We're rating on Mr. Ascot. Huh?
Did we do the meeting days?
Yeah.
We have a court. No, we have a
Huh?
night.
Just continue. And Dana was just continue.
That other guy's not in jail, by the way.
Angelo is not?
It's not nice J.
They just,
Did they release him in the last day?
I mean,
Wouldn't it be the
Sarah
first
Donnelly
time?
spoke with him yesterday afternoon.
Yeah.
Okay, let me see what's happened.
I'm looking at the roster right now. He's not on it.
So it changes things.
All right.
Yes, and she continuously is emailing.
All right, so I'm gonna wait on Miss Pizzardi.
Yeah, I've got no one coming up.
What's that?
I've got no one coming up for him.
No, just to be clear, his name, by the way, is misspelled by the prosecutor's office, so now the court has it misspelled. It's M-A-R.
M-A-R.
Yes.
That makes a difference.
It does. M-A-R-G-E-L-O-T. It
Well,
is,
that explains why I didn't put him on the jail list, because his name's not spelled right. So I didn't put him on a jail list.
so let's just, yeah, so he's not here.
He is still in custody.
Yeah.
That would be the problem.
All right, so do you want to use that prelim date for PCC date? Because that's definitely just cause. Or we can just leave it on for prelim. I'll leave it completely up to you. Mr.
Would you mind if I just called them and saw if they could just put him in that room?
Yeah, you can do that. Nope. We're not going anywhere because although Miss Pizzardi is gonna be, you're gonna get the full show, Miss Miss Wilson. You may want to sit back there and wait because
Could use a little.
It was scheduled for 10. At what point do we just call the case? The attorney, I don't know why the attorney's still not here.
it's I'll give him till 11. On a snow day, I think I've got to be somewhat flexible, but Mr. Asfak is not here.
Trowbridge at 127 in Harrison is completely closed due to an accident.
Yep.
Missing person is.
Well, we
missing.
can grant her adjournment.
And.
She's requested an adjournment.
That's what she keeps emailing me about.
North of Jolly has 127 north of Jolly Road. It has been shut down due to a separate accident.
Well, let's get until 11 and then we can adjourn and I'll bring Miss Pizzardi in and give her what she requested.
Okay, so he's finishing up eating right now, and then we're probably there in 5-10 minutes.
All right.
If you're in jail, I guess you can't go back and eat later either. So
Well, I mean, they have their process.
Yep.
I'm gonna go just set up in one of the rooms over here.
All right.
Old.
Yeah, we did.
The only thing we have left is Luke's client and.
We have,
Already.
and it's AR, right?
Yes.
I amended it in JIS.
Somebody corrected with an E.
That explains why. I couldn't
Yeah,
find it.
on our file, it says M, and they did a whiteout to an E, and that's why we have the wrong. So Margalot. And it is ME on this.
Yeah, it's an ME in our
On
system as
everything,
well. I'll
yeah.
update our system.
Mr. Hopkins is gonna get all the way here and we're gonna turn it. I'd much rather just have the hearing. Are you a representative of Fountain Place?
Yeah.
Yeah, so we're waiting on our attorney right now. We should be hearing in
All right. But we're gonna give them to 11. All right.
a minute. I'll let them know.
And then but I'm not, the plan is Miss, and you'll hear all this. Yeah. Ms. Bizzardi, are you there? You'll have to unmute yourself. Stacy Pizzardi, you'll have to unmute yourself. Ms. Pizzardi, if you don't unmute yourself, then you won't be a part of this hearing. Does she have audio?
Yeah.
All right, Ms. Pizzardi, are you going to unmute yourself? I'll give you a couple of minutes. Then we'll remove you from the conference, from the hearing. But you should unmute yourself. We're about an hour late. I can see you're here. I've admitted. Okay, thank you. So, ma'am, are you Stacy Pizzardi?
Yes, but
All right.
this to be rescheduled because this.
All right. Let me call the case, and then let me call the case, and then you can make your argument. All right. So we're on the record in docket 230349.
I cannot legally make an argument because I am disabled. You are breaking the law by holding this meeting.
All right, you can have her removed now. You can have her removed. All right. So we're on the record in 230349. That is Fountain Place Limited versus Stacy Pizzardi. Will the parties please introduce themselves for the record, Mr. Asphalt?
Good morning, Judge Christopher Asphalt, 53129 on behalf of the plaintiff.
All right, thank you. For the record, Ms. Pizzardi was initially indicated that she could only join us by Zoom as part of her disability. I granted that accommodation. Ms. Pizzardi has been in contact with the Civil Department of 54A on various emails. I think I have, we received one at 2 a.m. I will state that for the record. Ms. Pizzardi indicated in her email, "You're breaking the law. I cannot attend. And if you attempt to write a warrant for my failure to attend, that's just adds to the proof, in fact, that you're legally trying to murder me for femicide and hate crime reasons, meaning that you're clearly trying to cover your ass for trying to imprison me for clear racist, sexist, and ableist BS. I wasn't born yesterday. Do your job or enjoy prison." She said, again, "You're breaking the law. I cannot attend. If you tend to write a warrant for my failure to attend, that just adds to the proof. The fact that you're illegally trying to murder me for femicide and hate crimes." Those were received at 138 and 142. I have on 833. My office has been in contact with her. She indicated that she wanted an ADA accommodation to adjourn the matter. I told her that I would not adjourn the matter, but that I would allow an accommodation for her to attend by Zoom, assuming that she followed rules and didn't yell at anybody and didn't scream at anybody. it was then that we called the case a little later today. This was scheduled for 10 o'clock. There, we have a snow day here in Michigan, so to speak, with horrible conditions and many ways to get here that are shut off. So the courts tried to be flexible with any of the parties coming. Ms. Pizzardi joined us at 10. We told her to come back at 10:45 by email so that she could be a part of this hearing. Then, as the record just indicates now, I did call the case. Ms. Pizzardi actually went into her argument as to needing more time for the adjournment because she's not been able to get an attorney. I will indicate for the record that this initially came to February 7th, 2024, when it was initially set for formal hearing. On February 27th, it was set again for formal hearing to allow Ms. Pizzardi to get any ADA requirements, to get any ADA materials to the circuit court or opposing counsel, and to get ADA an attorney, which she said she had in February 7th of 2024. She indicated that she had an ADA and attorney, so we adjourned it so she'd have time to talk to her lawyer. On February 27th, in the meantime, we were told that the court received notice she did not have an attorney at that time. Mr. Asfak, who was the opposing party representing Fountain Place, indicated that he had not an appearance filed or anything along those lines. So we adjourned to today's date, March 22nd, in order for Ms. Pizzardi to get an attorney or any ADA, request any ADA. We've received nothing from the ADA or that Ms. Pizzardi comes under the purview of the ADA requirements. We have no documentation was ever provided to the circuit court, to the district court. The only thing we have done is I've granted her her request to be here by Zoom. I did not grant her request to adjourn this matter. Then the email started, the phone calls, and on today's date, Ms. Pizzardi, I called the case. Mr. Asfak was ready to say his appearance. Ms. Pizzardi kind of went off on her argument. I asked her to, you can hear it for yourself, it's all on the record. I asked her to wait while I called the case. And then she indicated that several things, and then she hung up. And so she's not present here. Mr. Asfak, I almost forgot if I've asked for your appearance or not. So, so your appearance for the record, if you haven't already.
Yes, Christopher Asphalt, 53129 on behalf of the plaintiff.
All right, this is the time set for a formal hearing today. As indicated before, it was set previously on February 7th. We've adjourned it to February 27th. We adjourned it once again to March 22nd, 2024. It would appear that Ms. Pizzardi has failed to appear. We've had some issues with communication with Ms. Pizzardi. To put it bluntly, she's yelled at the court. She's yelled at opposing counsel. She's yelled at staff. She's yelled at the 54A, my staff. So we presented her with the option to coming today, and she yelled at the staff, and she yelled in court. So she's been removed. She's left the Zoom courtroom. So on the March 22nd, 2024 date, we are set for formal hearing. Mr. Asfak, how would you like to proceed?
Your Honor, I would request entry of a judgment of possession. I guess it would be as a default judgment.
It would be a default judgment. And that would be for failure to appear of Ms. Pizzardi. She did appear briefly. I would make a record. She appeared briefly earlier. We had some sentencings that we were doing. She appeared later. We called the case. She argued and left, and that's really been the experience so far.
Just to be clear, she didn't leave. You told me to remove.
Yeah, I removed her after her yelling. I removed her, and then is she still?
No, you had me remove her from meetings. So
All right.
she's gone.
All right. So I moved her from the Zoom courtroom. This would be a default judgment. Do you want to place any numbers on the record?
Yes, Your Honor.
Mr. Asfak.
There's currently rent to retain $3,838. Court costs $155 for a total amount due and owing of $3,993. I would request a writ to entry date of 10 days from today's date. What would that be?
I think that's April 2nd. Is that right? April 1st. April 1st.
shall I approach that, or do you want me to e-file it? Or
Why don't you, I think you're better if you e-file it, because then I can sign it, e-file, and that makes certain that it's done. I have a paper file. All right. I've lost track between paper and
Right.
e-file. So, all right, so because I have a paper file, I will sign the order accordingly. I will sign the April 1st as the appeal date. As indicated before, Ms. Bizzardi was here previously for a period of time. She was yelling at the court. We've had some problems with communication, so that I removed her from the Zoom courtroom, and I don't see her now. She's been removed completely. She was requesting an adjournment. That request was denied, and she was told to be here, and she said she wasn't coming per her emails, but then she did show up. I will sign the document on the third adjournment. So that's signed as March 22nd. And you can get a copy from my court officer, Mr. Neves. Anything else for the record in 23-03-498, Mr. Aswak?
No.
All right, thank you. All right, Mr. Goodrich, are you ready on Mr. Margolo?
No, Your Honor, I do need to speak with Mr. Margolo briefly.
All right, I'm gonna put you both in a breakout room. Let's see. So you should get a prompt, Mr. Goodrich, to go to room 2. And then Mr. Margolo, you'll be taken to room 2. I seem to have lost my patience for getting yelled at.
We're all set, Your Honor.
Yeah.
All right, so we're on the record in docket. Let me find where we are. 24-00703. That is People of the State of Michigan versus Patrick Margolo. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Goodrich.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Margolo, who's appearing over Polycom from the jail today.
All right, thank you. And sir, you are Patrick Margolo, is that correct? Is that a yes, sir?
Yes, Your Honor. Yes.
Okay, thank you. And you can hear me all right, Mr. Margolo?
Yes, Your Honor.
All right, thank you. This is time set for probable cause conference. Ms. Wilson, how are we proceeding, or would you like to defer?
I would defer, Your Honor.
Mr. Goodrich, how are we proceeding today?
Thank you, Your Honor. At this time, we would like to leave the matter set for a preliminary exam next week.
All right. So the preliminary examination is set for March 28th at 9 a.m. At this time, the probable cause conference was held, and we'll see everybody back here live in person on March 28th at 9 a.m. for the preliminary examination. Anything else for the record in 24-00703, Ms. Wilson?
Nothing from the people.
Mr. Goodrich?
No, Your Honor. Thank you.
All right, Mr. Margolo, we'll see you back here on March 28th at 9 a.m. Thank you for your appearance today.
Your Honor.
Yes, I'm done. Thank you.